Good morning, good afternoon, good evening, everyone. Welcome to our first session in our 2022 Shipowners webinar series. A warm welcome from Watson, Farley and Williams to our series called Riding the Wave, Staying the Course. My name is Christian Finnan. I'm a maritime partner of the firm based in Hamburg. Personally, I am heading the Hamburg office as well as leading our German corporate services group, which is with a focus on the transport sector, but also beyond, advising on a range of maritime law topics, many shipbuilding contracts these days, but the broad range, as well as corporate law matters, tax law and dispute resolution. I'm very happy and delighted to welcome you from the entire firm, and in particular as a co-head of the global Shipowners campaign here at Watson, Farley and Williams. We are very pleased to also once again this year bring you a series of webinars on subjects we believe are key to understand the interest, the topics in the operating of the maritime sector. I would like to remind you that this is just the first of a series of two. We have two further webinars to come. Next Wednesday, my tax partners, Daniel Pilarski, Verena Scheiber and Rick Stevens from the offices around the globe in New York, Hamburg and London will be discussing the global tax reform and how that will affect the future of taxation in shipping. So an exciting topic, I think, and worth to join. And then on 29th of June, once the celebrations of Posidonia have been overcome and done, my employment law partners, Devon Kagram and Andreas Wiegelfe in London and Hamburg, will be hosting the third series about employment issues in maritime, crewing, obviously very important these days, works councils and beyond. So if you haven't done so already, I take the liberty to encourage you to register for these two additional webinars of our series. Before we get started, may I remind you that we are very welcome, as always, to take your questions. For today, the most convenient way would be to use the Q&A function of Zoom. We collect the questions and then try to answer those, if time allows, at the end of the presentations. But of course, as usual, if you have further questions coming up or time doesn't allow today, you're always free to approach us by phone, by email, or via LinkedIn. It is now, turning to the topic of today, my great pleasure to welcome Valentina Keys and Nick Walker. Nick is a partner of mine in the Planning Regulatory Group in London, who is focusing on providing clients with contentious and non-contentious advice on planning, environmental, health and safety law advice across a range of sectors, but particularly in relation to today's discussion and generally in the current environment, the maritime sector we are as a firm in. Valentina is a senior associate in the Environment, Health and Safety team, who regularly advises clients on various aspects of net zero, European Union Green Deal, Fit for 55, European ETS, ESG reporting, EU taxonomy, circular economy and wider sustainability, climate change, decarbonisation issues applicable across a range of sectors and the maritime sector in particular. Today, obviously, Nick and Valentina are going to be focusing on the maritime space we are all in here together in the call, where various issues relating to environmental, social and governance, that are known as ESG, have been front and center in the industry for a number of years now. Two particularly pressing issues within the wider context of ESG in the maritime space are ship recycling and EU emissions trading scheme, or EU ETS, and how to ensure your business in its compliance with these important but sometimes challenging regulations. So the challenges in environmental compliance, ship recycling, and ETS are the topics for which I'm very happy to hand over to you, Nick and Valentina.
Thank you, Christian, and hello everyone. Before we get started, I would just like to wish everyone a happy International Day for Women in Maritime. I note the themes this year are training, visibility and recognition, and I'm sure you don't need me to mansplain why that's very important for the maritime industry. We've got quite a lot to cover today, so we're going to skim through at a fairly brisk pace, but if you do have questions, as Christian mentioned, please put them in the Q&A function and we'll do our best to answer them at the end. Right, so when we look at the decarbonisation agenda, there's a number of legal and commercial drivers which are set out on the slide. There's a Paris Agreement, which involved nearly all of the world's nations signing a declaration to commit to limiting global temperature rises and to reach net zero between 2050 and 2100. There are also provisions to set emission limit reduction plans, which are reviewed and tightened every 5 years, and to provide climate finance for poorer nations. COP26 and the Clydebank Declaration, which came out of it, set out plans to establish green shipping corridors and zero emission shipping routes. The IMO greenhouse gas target is to reduce emissions by half by 2050. There is the EU Green Deal and Fit for 55 package, which we'll be discussing shortly. And countries have individual targets, and corporates also have individual pledges outside of legal drivers. Just quickly dealing with COSEV, which is a cargo owner-led platform to decarbonise the maritime supply chain. And just a reminder of MEP 78, which is fast approaching and could see a global carbon levy coming in.
So the purpose of today's session, as Nick mentioned, is to update you on decarbonisation agenda and the direction of travel, particularly what's being done to reduce emissions in the maritime sector. So we thought we'd begin at the beginning, which is with saying a few words about the EU MRV regulation, the Monitoring, Reporting and Verification Regulation 2015, which began to apply from 2018 to ships that are more than 5,000 gross tonnage, commercial ships carrying cargo and passengers and sailing to and from EU ports. So from that date, ships have had to report on their carbon emissions, on the weight of cargo and passengers and energy efficiency, amongst other factors. And key compliance deadlines each year for the MRV system that applies to ships is 30th of April and 30th of June. So by 30th of April each year, ships falling within MRV regulation have had to submit an MRV report and basically set out what's their carbon footprint for the previous compliance year. That report has to be submitted as a flag state. And then, provided everything's in order and everything adds up, a document of compliance is then issued to the ship, which must be kept on board. And failure to have a document of compliance on board is an offence and could expose ships to fines, ship arrests, master arrests, and public naming and shaming, so publication of those fines. And of course, there are other issues that would be put into place, such as insurance contractual ramifications of non-compliance and reputational damage as well. So the importance of the EU MRV system is that it was the first step towards the introduction of the emissions trading scheme or some sort of market-based mechanism or levy for shipping, so putting a price on carbon. easing in the shipping industry into the polluter pays principle, which we'll talk about in more detail in a moment. And just to note that it's the 2018 and 2019 data that's currently being used by shipping companies as they seek to calculate the costs of compliance going forward, particularly under emissions trading scheme, which we'll talk about in a moment. So that's the EU system for carbon reporting. There's also the global system, which is the global fuel oil data collection system. It was introduced 1 year after the European one, and it has a slightly broader scope in that it applies to all types of ships, so not just commercial ships that carry passengers and cargo. It's been applicable since 1st of January 2019. Also applies to ships above 5,000 gross tonnage. And from that date, those ships have to collect and report on the fuel that they use. And there are all sorts of fuels that are reportable, and monitoring is done either through bunker delivery notes or flow meters, or by installing a bunker fuel monitoring system on board, which many shipping companies have been doing. So the purpose of the global fuel oil data collection system is to lead the shipping industry towards the polluter pays principles, this internalization of externalities of shipping, and ultimately to introduce either a carbon levy or a different market-based mechanism, which could be a global emissions trading scheme.
So the Fit for 55 package, which was announced by the EU, was it June last year?
Yeah, 14th of July 21.
So in July last year, sought to sort of attack the problem from all angles. And I think it's recognised that maritime has a slightly different problem to other industries, and it's hindered by a lack of available alternative fuels or readily deployable technologies. So the EU has brought in a raft of measures to try and address this. There is the Fuel EU Maritime, which aims to incentivise the uptake of renewable and low carbon fuels, so pushing innovation. There is the EU ETS, which we will be discussing shortly, which is a cap and trade system, which is designed to move progress forward. There is the Energy Taxation Directive, which removes exemptions on bunker fuels for in order to try and make attack the tax issue and make low carbon fuels more cost effective. And there is the alternative fuels infrastructure, which is dealing with trying to obtain infrastructure reform.
So emissions trading for maritime, there's been a lot of developments since this original draft proposal, which, as Nick mentioned, was introduced on 14th of July 2021 as part of the Fit for 55 package. And so the starting position was that ships that are 5,000 gross tonnage or more would be required to report and surrender allowances, so emission allowances for the carbon that they emit and that they report on already under the MRV scheme that I've just covered. And they would have to do so from 2023 onwards on an incremental phased basis. So the surrender of allowances wouldn't have to be in full to begin with. The shipping industry would be eased gently into it. So starting from 20% in 23 and then moving to 100% in 2026. And there was a lot of question marks in the original draft as to who would pay for this. The draft suggested it would be the shipping company who would be the polluter, and the shipping company is defined quite widely in the proposal. It's the shipowner or the entity that assumes responsibility for compliance, which could be the bareboat charterer or the ship manager, or anyone who assumes responsibility for fuel, for speed, for route, for cargo. So the definition is quite broad. We think that it's purposefully so. because really the regulator is concerned with making the polluter pay. And if that definition includes different parties, then, you know, that's up to the commercial world to sort that out. So I have to say that the proposal has moved on quite a bit since then. And I think it would be helpful to take it to the next slide to show you how. There we go. So this little comparison table shows the original proposal and also the proposed amendments that were introduced by EU Parliament in January this year. And EU Parliament was basically calling for all of the emissions, both European and non-European ones, to be reportable under the emissions trading scheme. So the non-EU ones would be reportable by shipping companies from 2028 onwards if the IMO fails to introduce an equivalent, you know, emissions trading scheme or, you know, carbon levy. So that's one thing. There was also an important amendment proposed in terms of who would pay. So the Ets Costs Clause, which would basically provide more certainty as to how costs for compliance with emissions trading would be allocated and apportioned between the parties in the maritime industry, because at the moment the draft proposal is too vague on that point. As you can see, there is a 100 euros per ton excess emissions penalty that would apply wherever there is a shortfall in reporting, a shortfall of allowances. And that seems quite high perhaps, but not when you take into account that at the moment, the price of carbon is around 85, 90 euros per ton of carbon. So query whether that emissions penalty would be enough to deter non-compliance. So it remains to be seen. But there's been a really important development overnight because the vote took place yesterday at the Environment Committee, and basically all of the proposals for the expansion of ETS and for making it more ambitious were adopted yesterday. So I thought we would just summarize what the key highlights of the revised ETS proposal are at this point in time. So very importantly, now shipping companies will have to report not only on CO2 emissions, but also on methane and nitrous oxides. And that list of greenhouse gases that would have to be reported under the ETS would be regularly reviewed and would potentially extend to other greenhouse gases and black carbon as well. So that's one development. Secondly, from 2024, ships between 400 and 5,000 gross tonnage will have to report their emissions under the MRV scheme. So the MRV scheme will be revised now and its scope expanded. And then from 2027, ships of that size will also have to surrender allowances under the emissions trading scheme. And also of note is that from 2024, ships performing service activities for offshore installations will also be covered. So not just commercial ships that carry passengers and cargo, as was originally proposed. Moving on, until the end of 2029, special conditions will be introduced for ice-class vessels and navigation in ice conditions, as well as voyages from and to outermost regions and its member state. The Ets Cost Clause has been adopted, which seeks to place the responsibility, at least contractually, on the commercial operator. And it's still not clear whether that would be a binding clause, whether it would be a recommendation, whether it will be retroactively applicable. There's still question marks around that. There's also going to be a creation of an ocean fund, and proceeds from ETS will be allocated specifically for maritime, as will proceeds from the Fuel EU Maritime Regulation. So key takeaways: there's no phase-in period anymore. ETS is to apply from 2024 to ships that are 5,000 gross tonnage and more, and then that threshold will widen as the emissions trading scheme progresses.
So who is the polluter? Valentina mentioned earlier that the drafting in the directive is deliberately vague, we think, because the Commission is just concerned about capturing the emissions. And so it could be any one of these entities here, and it really depends who you're talking to as to who people think it should be. I think Valentina mentioned that it's normally the entity that's responsible for choice of fuel, route and speed, but of course it's never as straightforward as that when you're dealing with commercial arrangements and different charter periods and different contractual provisions as you have to in the real world. The costs of complying with the scheme are going to be significant, though, not just in the administration that will be required to register, to calculate emissions and to participate in the scheme, but the actual cost of voyages as well will be significant. So we've been working with a broker over the last few months, and they've given us some rough calculations based on the cost of an allowance being around 84 euros. And so a handy sized tanker performing a cross-med voyage faces costs of $5,300 per day. It will be half that initially, but I mean, that's still significant. A Capesize performing a Shanghai to Rotterdam route will have a cost of $4,800 per day. And based on that's based on paying for 50% of the emissions as it's currently required. So on a 35-day voyage, that's about $165,000. So quite significant.
Yes. So how can you prepare? Early action is really important, obviously, and we've already been talking to ship owners and charterers and ship managers and commercial operators as to how they can prepare and how can they apportion costs and manage that risk going forward. So some of the key kind of initial steps to consider is you might wish to map out the MRV data and map out the potential cost of compliance based on that MRV data. Also work out where the shipping company is registered and where the registration for ETS is likely to be, and look at ways how costs can be passed on, if that's feasible, if that's workable, depending on the commercial relationships that you have with your customers. A one-size-fits-all BIMCO clause would not be sufficient to protect your position. For example, it doesn't cover things like enforcement and also recovery of any costs that your customers fail to meet.
I think even if it's coming in 2024 now, it's very unlikely it's going to be delayed again, because the Fit for 55 package is aiming at reducing emissions by 55% by 2030, which isn't really all that far away. So it's time to start planning now, because there is the rest of this year and next year to get provisions in place. But if you're entering charter agreements that will still be operating once this scheme comes into force, you need to have provisions in your contracts now that allow the calculation and allocation of liabilities, because it's too late afterwards. And I think it's going to be the first few years of the scheme are going to be difficult for everyone. It's going to be a while before people learn and work out how to make this work, but it's coming, and so we have to deal with it.
Yeah, and there's about 45 different carbon pricing mechanisms in the world. So imagine if shipping companies had to comply with each one of those. That's far from an ideal scenario. So obviously there's, you know, an urgent need for a global harmonized approach. And that's why there's so much pressure being put on the IMO. Hence, you know, partly the reason for the emissions trading scheme being made more stringent, more ambitious, seeking to capture all of emissions, including non-EU emissions from 2027 onwards. And UK is also looking to introduce their own emissions trading scheme for maritime. There's currently a consultation running on this. It closes on the 17th of June. If anyone feels the need to respond, please do. I can certainly share the details of that consultation with you if that's of interest. But it's very interesting that UK is looking at not only putting the responsibility on the commercial operator or the shipping company, but also introducing some sort of hybrid system whereby responsibility is shared between shipping company and fuel suppliers. So it'll be very interesting to see how that pans out and if there's any support for that as well.
Okay, so now we're on to the sort of other end of the sustainability agenda. So dealing first with decarbonisation in fuel primarily and infrastructure. Now we're looking at ship recycling, which is the big issue on the environmental maritime agenda.
So we mentioned the polluter pays principle, which is a new concept for the maritime industry, as is the circular economy concept. You know, designing out waste and thinking about life cycle approach is not something that has been inherent in the shipping world, but things are certainly changing as part of this decarbonisation agenda and rush toward net zero. And you know, various sectors becoming more resource efficient or seeking to become more resource efficient and thinking about you know, eco-design more and how to recycle more, recover more. So steel, for example, how can everyone, you know, capitalize on that? So in this part of the presentation, we'll just bring you up to speed on the responsible ship recycling agenda and how that's been progressing. There's been a lot of case law in this area. Companies are being held to account for basically allowing their ships that were previously owned or currently owned to be illegally beached and you know, dismantled in very poor health and safety and environmental conditions. So that is the reason behind the Hong Kong Convention for Responsible Ship Recycling and also the EU Ship Recycling Regulation, which we'll talk about, which implements the international convention, which, as we'll talk about, is not yet in force.
Okay, so some key principles which, whenever we're talking to clients about ship recycling, is the first place we start, because primarily ship recycling is tied up with waste law, and it's critical that if you are thinking about recycling a vessel or scrapping a vessel, or you're selling a vessel and there is a chance that it will be sold for scrap, whether through an intermediary or a broker, you need to start thinking about it in terms of waste and waste law. So some key principles here are waste, which is any substance or object which the holder discards or intends or is required to discard. Now, once something becomes a waste, waste law applies to it. And that can go as far back in the decision-making chain as deciding that you're going to sell a vessel because it's not worth putting it in dry dock or getting it recertified. At that point, you are already intending to discard it, and waste law applies. A few other terms: recovery is an operation which results in waste serving a useful purpose, so it doesn't change its status. An example of this would be stripping lights from one vessel and using them as lights for another. Recycling is the reprocessing of a substance and for its reuse. So the obvious one in shipping is steel. Disposal is the final disposal of something, meaning that it's no longer possible to use it for any purpose, and it's essentially thrown away. This is critical when it comes to hazardous substances, of which there are many on vessels. And then ship recycling, I won't read the definition out, but you'll see it has elements of all of those concepts that we've just discussed.
So we've talked about the polluter pays principle, which is the commonly accepted practice that those who produce pollution or profit from it should bear the cost of managing it. And that cost of managing it could include things like remediation costs, use costs, compensation, etc. So as I mentioned, it's about internalizing externalities of shipping, life cycle thinking, life cycle approach, thinking about the footprint of the industry and how to minimize that. And there's also the precautionary principle, which is another central component of environmental law, and a very sensible risk management tool as well. And it's probably not as widely used as it should be, which is why we have cases like the Felicity A ship fire case, which was carrying a whole lot of lithium batteries in electric vehicles, and all of that went up in flames. Huge financial but also environmental damage arising from that, and that's mainly due to the lack of the precautionary principle exercise and obviously a poor risk management and risk assessment that was done in advance to really identify that it's very, very dangerous, very risky to carry lithium-ion batteries by sea, particularly because of the fire risks.
So just a quick look at the key international law provisions. There is the Bile Convention, and that is brought into EU law directly by the EU Waste Ship Regulation. The Bile Convention deals with the movement of waste from one country to another and puts a system of control in place. It bans the movement of hazardous waste from essentially the first world to developing countries. And it's aimed at stopping people from sending their waste for treatment in poorer environmental and health and safety conditions in order to avoid the costs of proper disposal. There are specific treaties and regulations regarding the recycling of ships. I should just say that the Bile Convention is generally, and the waste shipment regulation is generally aimed at the movement of waste. But if a ship it can become a waste, as we mentioned earlier, then it falls under those provisions as well. The Hong Kong Convention is specifically aimed at the recycling of vessels, and it also has provisions in it around designing out hazardous materials and unnecessary parts of vessels so that disposal can be more easily and safely carried out. The EU Ship Recycling Regulation, again, just directly applies the Hong Kong Convention with a couple of exceptions relating to slightly different, so there's a few more substances which are included in the Ship Recycling Regulation. But that it's just brought into EU law with the aim of trying to bring the Hong Kong Convention into force. So the Bile Convention, I think I've covered most of this already, but just to note that it's currently in force in 187 countries, not the US, which never ratified it. And there is a Basel ban amendment as well, which bans the movement of shipments of hazardous waste from OECD countries, the EU and Liechtenstein, to non-OECD countries. So that's an outright ban, and that came into force in 2019, but it was already enforced in the EU through the waste shipment regulation.
So the waste shipment regulation implements the Basel Convention, as Nick mentioned, at EU level, and includes the Basel Amendment on exports of waste for disposal. and exports of waste for recovery under the waste shipment regulation are permitted only if they're made to OECD decision countries. So India, Pakistan, Turkey, for example. And when those exports are made to those OECD decision countries, prior written notification and consent is required for those shipments. And as Nick mentioned, exports to non-OECD decision countries are prohibited, subject to a few exceptions. But that doesn't necessarily mean that this regulation is complied with. Far from it, and it's currently being reviewed. There's going to be more restrictions introduced, more checks for waste that is exported. So continuing that duty of care to make sure that it does reach the required destination, that it does get treated in ways that are set out in the prior written notification. Because you know, as the picture with the plastic waste demonstrates, unfortunately, there's a lot of non-compliance happening, which is polluting our oceans and generating a lot of waste dumping, particularly in developing countries, which really shouldn't be happening.
Just quickly on the prior informed consent point, it's very common to have to go through that procedure if you are shipping things like aluminium residues or you know, plastic waste, or which actually is going to be banned very soon. But it's quite different if you are trying to move a vessel under the prior informed consent process. We've certainly had occasions in the past where we've been advising clients and they have tried to go through the prior informed consent process, but the ports where they're at and where the recycling was due to take place just don't have the capacity to do it, or aren't aware that you are supposed to do it, which makes it quite difficult if you've got regulators sniffing around, as they were in this case, to do the right thing, because you know it's not you know, countries just aren't set up to do it, which is why the Hong Kong Convention and the ship recycling regulation came about, essentially because kind of waste ships were slipping through the net.
Just a few more points about the Hong Kong Convention. So it's not yet enforced, as we mentioned. It was introduced in 2009, and you know, to enter into force, it will need a lot more countries to sign up, basically, and the last country to sign up was Spain. So there are now 17 states that have acceded to the convention, and importantly, it's the first step towards the circular economy concept being exercised by the shipping industry, particularly because of this concept of the inventory of hazardous materials that needs to be kept on board the ships. It's a live document. It needs to be put together when the ship is built, and then it needs to be kept up to date, and the inventory needs to be kept up to date throughout the life of the ship, and then it needs to be submitted as part of all the ship recycling documentation when the ship comes to be scrapped. And another key requirement of the Hong Kong Convention is that requires end-of-life ships to be recycled only at authorized facilities in accordance with a ship recycling plan.
Just quickly on that, the Hong Kong Convention isn't in force yet, but there are a lot of yards which are certified according to Hong Kong Convention standards. So even if you are dealing with a vessel which isn't EU flagged, and you are recycling it responsibly or selling it to someone and you want to ensure that it's recycled responsibly, it's quite possible to have provisions in MOAs that stipulate that it must be a Hong Kong Convention approved yard that's certified, and it has to be audited, the process of recycling and so on. So there is a sort of shadow operation of this convention already. So the ship recycling regulation, as I mentioned, it was came in 2013. Again, the EU's attempt to try and bring Hong Kong into force and deal with the issue head on. It was fully into force in 2020. It's probably fair to say that the arc of this story is not quite how the EU anticipated, and it's not particularly popular, particularly in yards in Asia and with EU flagged vessels as well. It applies to any EU flagged vessel, and there are provisions around what you should carry on board in terms of inventories of hazardous materials, which apply whenever any vessel is in EU waters. I think the difficulty about it is that the capacity to recycle in approved yards, which is what you have to do if you're EU flagged, isn't matching the number of ships that require recycling. So it's affected prices more than it should have done. We were advising clients recently, and the difference in value from what they can get for a vessel for recycling in an EU approved yard is about half what they could get from a Hong Kong Convention approved yard in India. So that doesn't really reflect the cost of additional compliance, which is what going to an approved yard should cost. What it's reflecting actually is the fact that there isn't the capacity to recycle it. So the yards can pretty much name their price, which is having an unintended effect, and it's resulting in a lot of vessels just being flagged out of the EU. The regulation is due to be reviewed at the end of next year, and I think it's probably quite likely that there will be amendments made to it to address this issue. But in the meantime, it's not particularly helpful for those with EU flagged vessels reaching end of life.
Yeah, and just to add to that, there are plans to issue a call for evidence and consultation on the review of the EU ship recycling regulation and the ship waste regulation as well, towards the end of this year, with a view to introducing revised drafts in 2023. So watch the space on that. This is hopefully a helpful slide for those of you that have to make decisions as to whether something is or isn't waste, and if it is waste, which laws would it fall on. So if we take, for example, the example of when a ship is EU flagged, in that scenario, the EU ship recycling regulation would always apply, and the EU waste regulation would not be applicable. Similarly, when a ship is flying the flag of a non-EU member state and is outside of EU waters, and for example, the decision is taken to scrap the ship, then EU ship recycling regulation is not applicable, and the EU waste regulation is not applicable either. And then you take the example of a non-EU flag inside EU waters. What would happen then? Well, the EU ship recycling regulation is partly applicable because the ship would have to carry on board an inventory of hazardous materials. That's been applicable since 2018. And then the EU waste regulation is also applicable, and a private notification would be needed, and any infringements would be a criminal offence. In the case of ships that flag out, for example, they go from being EU to non-EU, yes, the EU ship recycling regulation would not be applicable in the first instance, but the decision would very much rest on where was the decision taken. Because if the decision is taken in EU waters, then potentially the ship recycling regulation would be applicable. So it's all very, very complex, and certainly it gives much food for thought.
Okay, so just quickly on this slide, because I'm conscious of the time, just a couple of things to point out. The difference between the specific ship recycling law and that which is just aimed at waste generally is set out in the scope part of this table. But it's just worth bearing in mind that if you're recycling under Basel or the waste shipment regulation, it covers you're potentially on the hook for liability right up until final recovery and disposal. So if you are deemed to be holding the waste, and if you've sold, let's say you've sold a vessel and it's a regulator is alleging that you were aware that it was going to be taken outside of to a Basel country where a prior informed consent was required, or to a non-Basel country, you are responsible right until the very end of the recycling process. Whereas with the ship recycling regulation and Hong Kong, essentially you go through a process of getting approvals for the recycling. You have a recycling plan that's approved. The facility of the ship recycling facility will prepare a plan, and once you hand over the vessel, your liability comes to an end, and it becomes the ship recycling facility's responsibility to deal with that vessel properly. Just quickly as well on the Basel issue, there is quite a lot of debate around why vessels in the subcontinent can't be approved under the EU ship recycling regulation, so they can be approved facilities, which would certainly relieve some of the pressure on the approved yards, and perhaps sort out the issue around pricing. But this is it's primarily because of the issue of beaching. But even in Basel, that isn't strictly allowed, because impermeable floors are required for full containment once a vessel starts being taken apart. So end of life, I think I touched on this briefly earlier. The law talks about preparing to send a ship for recycling, or ships destined to be recycled, but that doesn't necessarily mean that it can't continue operating as a vessel before it becomes a waste, and these laws and regulations apply. In a lot of the cases where people have been found to have been in breach of the waste shipment regulation, for example, the vessels in question have been on voyages, they've had cargo, but the decision to scrap them has already been taken. And so the fact that a vessel is carrying a cargo doesn't mean that it's not a waste. And that's something that you need to bear in mind. You really need to take it back as far as possible to the point where the decision is made that you are no longer going to be using this vessel for shipping, even if it's within a couple of months. Arguably, it's already a waste, and these provisions already apply.
Yeah, that actually brings to mind the sea trade case. Many of you will have heard of it. In that case, sea trade was found to be guilty of breaching the ship recycling regulation, and it was found that they sold 4 ships to a cash buyer who ended up scrapping the ships in beaching yards in India. 2 company executives were banned for a year from working anywhere in the maritime industry. No prison sentences were imposed in that case, based on the company's previous compliance record. They didn't have any previous criminal convictions, but in that case, the ships were carrying cargo, as Nick mentioned, and they were still seaworthy, certified, insured, operational, but the decision to discard the ship, to scrap the ship, and the intention to do that was evident, and the decision was taken when the ships were in EU waters, and this came out in the course of disclosures and case proceedings, and it was evident from the internal email correspondence.
So that's a quick timeline, which I think I've already covered.
Yeah.
So we just go on to straight into the next slide.
So enforcement is becoming more and more prevalent in terms of holding companies to account for illegal beaching, non-compliance with ship recycling laws, and port state control. They have many tools that they use to catch out non-compliances, drones, and lots of other innovative technologies. But specifically in terms of ship recycling, they would be looking out for any kind of ship recycling documentation on board, anything that would suggest that perhaps the ship is heading for recycling, even if that may be concealed by neatly put together files suggesting otherwise. So just something to be very alert to. There's very serious repercussions for non-compliance with ship recycling requirements. The main one being reputational damage, which can be irreparable, but also loss of credit, loss of insurance, and huge criminal fines as well. So the sea trade case that I just mentioned, the fines there were between $50,000 and $750,000. And more recently, there was a case, the Norwegian shipowner case, where the Norwegian shipowner was found to be in breach of the Norwegian ship recycling laws, and is facing 6 month imprisonment at the moment. So really something to take note of as being increasingly on the regulators and enforcement authorities' radar.
Okay, so IHM's only one thing we need to say about this is that when this provision came into force, we were in the thick of COVID, and it's very difficult to get people out to survey ships. The EU initially announced a 6 month moratorium. That has long passed, and there were some virtual surveys being carried out. But the point about the IHM is that it's supposed to be a living document, and it is supposed to be kept up to date, and as up to date as possible. So you do need to focus on making sure that it is as good as it can be now that restrictions are easing across the globe. Very quickly, we'll just deal with this case, which was a UK case around the fatality in a yard in Bangladesh, and how it potentially exposed a company which had an office in the UK to liability under the Fatal Accidents Act in 1976. Now, the claim was settled, and this was just an argument about jurisdiction, about whether the UK courts had jurisdiction to hear this. And essentially, the court thought that it did, because the argument made by the defendant was that the incident was too far removed in space and time, and from the deceased death for the company to owe him a duty of care. And the court disagreed with that. The defendant brought an argument forward that essentially they took the vessel ended up in Bangladesh, and that's where most of them ended up, and therefore it was a kind of normal procedure, which the court rejected, and said that it doesn't matter whether the standard practice was inherently dangerous. So it's really just part of the courts, not just the courts in the UK, but across Europe and in other parts of the world, seeking to stretch the bounds of their jurisdiction in order to accommodate ESG issues, and in order to find people responsible where practices are going on in other parts of the world which don't meet the high standards where, in the jurisdiction where the court is based. So it's something to really be aware of, is that it's very difficult. It's becoming increasingly difficult to just say, well, it's an SPV, so it doesn't matter, or I didn't know when it was sold. There needs to be due diligence around it, and you need to be able to sort of demonstrate that you've thought carefully when a ship is at end of life, or if it's likely to be end of life, about how it's going to be disposed of. And it's, it's fair to say that there are fatalities in approved yards as well, because it's a high hazard industry. But it's if that happens and you've taken steps to make sure that recycling will be carried out carefully and in line with high standards, then you're much less exposed to risk, either of liability or of reputational damage.
And there's a lot of good work being done in terms of R&D into best practice and what those high standards would look like, because really everybody wants global regulation. It's essential to, full kind of decarbonisation of the industry, and also multi-stakeholder collaboration is very, very key. And Ship Recycling Transparency Initiative, which now has 27 signatories, has done a lot of really good work and research into best practice in terms of ship recycling, steel recovery, particularly stainless steel, and how to design out waste at that design stage as well. So it's a key ESG risk, key ESG consideration. And one of the things that we advise our clients to do is to consider putting together a ship recycling policy, which shows that they've thought about it, that they've thought about responsible ship recycling, and are as prepared as they can be, but also consider ship recycling contracts review. Do you have ship recycling provisions in your contracts? If you don't, maybe consider having a chat to us about, how to basically make that happen.
Yeah, I think we've got just about time for one question, and the question is: under the EU ETS legislation for maritime, is there a contingent liability on ship financiers by way of lines penalties arising out of non-compliance, as there is in aviation? So in aviation, I think you can a regulator can hold a plane and sell it if penalties aren't paid. The enforcement provisions are set out by each member state, and they aren't made clear yet, but certainly vessels that are part of a shipping company which hasn't complied with its liabilities can be detained. I haven't yet seen anything about an ability to force sale, but that might come out once the enforcement provisions are brought in by member states. Okay, and I think someone else has asked about whether we will be sharing slides. We'd be very happy to do so if you get in touch with us. Thank you.